We know that dealing with probate can be stressful and confusing. The legal terminology, the numerous steps, and the time it takes can add to the emotional strain you're already experiencing. It's okay to feel overwhelmed, and it's okay to seek help. You're not alone in this. This video will guide you through each step of selling a home in probate in California. We'll explain what probate is, the difference between full authority and limited authority, and provide detailed instructions to help you navigate this process smoothly. Our aim is to offer you clear, compassionate guidance so you can focus on what matters most, honoring your loved one and taking care of yourself and your family. The steps of a probate sale. Probate is the legal process that occurs after someone passes away, involving the distribution of their assets. This would include personal and real estate property, according to their will or state law if there is no will. The court oversees this process to ensure everything is handled correctly, including the payments of debts and the distribution of assets to heirs. Probate is a legal process, so you need to have a verified probate attorney, advise, guide, and handle all the details, as well as a real estate agent certified in probate to help you navigate through all the complexities of selling a home under probate. The first step to selling the home is your attorney will file a petition for probate. A petition for probate is a legal document filed with the court to start the process of managing and distributing a deceased person's estate. It requests the court to verify the deceased person's will and appoint an executor, if named in the will, or an administrator, if there is no will, to handle the estate. The executor or administrator is responsible for paying debts, distributing assets to beneficiaries, and completing any other necessary legal tasks. In California, the probate process can vary depending on whether the court grants the personal representative full authority or limited authority under the Independent Administration of Estates Act, IAEA. Full authority allows the personal representative to sell the property without court supervision, though they must still provide notice to interested parties. Limited authority requires court approval for the sale, including a court confirmation hearing, making the process longer and more complex. After the court assigns the executor or administrator, it's their responsibility to inventory the entire estate. This includes all assets, such as bank accounts, stocks, personal property, and real estate. This step is crucial as it ensures all assets are accounted for and helps in determining if selling the home is necessary to cover debts and expenses. Probate law requires that certain parties be notified and given the opportunity to respond. This includes creditors, heirs, and beneficiaries. There are mandatory waiting periods for these notifications, during which nothing else can proceed. For instance, creditors have a set period of time to file claims against the estate. In California, the court will then appoint a probate referee. A probate referee is a state-appointed official responsible for appraising the value of your loved one's assets during the probate process. Their job is to ensure that everything is accurately valued, which is essential for fairly distributing the estate to heirs or beneficiaries. The estate's executor or administrator submits an inventory of all assets, which the probate referee then appraises. This involves everything from visiting properties to reviewing financial documents. Once the appraisal is complete, the probate referee submits a report to the court detailing the value of each asset, including the home. One important thing to remember is the probate referee does not go inside the home, so it's important that your agent is aware of the process, as they'll know to document any damage or issues that are inside the home. That way, they can get this information to the probate referee to help with an accurate appraisal. If not done correctly, this can cause problems and delays with the sale, especially if the administrator has limited authority. Once you have court approval, if needed, and an appraisal, you can list the property for sale. Working with an estate agent who has experience with probate sales can be very helpful. They'll market the property, hold open houses, and manage offers. The listing should disclose that the property is in probate as this can impact the timeline and terms of the sale. Be prepared for buyers who may need to wait for court approval. With full authority, the executor has the ability to sell real estate directly. The executor can list the property, negotiate offers, and complete the sale, all without needing the court's permission for each step. This flexibility can be a huge benefit in a fluctuating real estate market. With a limited authority sale, the executor must follow a more rigid procedure. After finding a buyer, they must file a petition for confirmation of sale and set a court date. During the hearing, the judge will review the terms of the sale and ensure that it's in the best interest of the estate. It's also possible for other buyers to present higher bids at this hearing. This is called overbidding, which can complicate the process further. It's also important to know that with limited authority, the home must be sold at least 90% of the appraised value set by the probate referee. Whereas full authority, the home can be sold at any price. This is why it's very important that you work with a real estate agent that's well-versed on the process of probate. Once the court confirms the sale, you can proceed with closing. The buyer completes their financing and the sale is finalized. The proceeds are then distributed according to the will or state law. After the sale, the proceeds must be used to pay off any remaining debts of the estate, including taxes, mortgages, and creditor claims. Any remaining funds are then distributed to the heirs as outlined in the will or by state law. And there you have it. Selling a home in probate in California involves several steps. Most California probate proceedings take 6 to 12 months and can even stretch past a year, and that's assuming that everything's going smoothly and no one's contesting. But with the right guidance, you can navigate it successfully. Remember, each situation is unique, so consulting with a probate attorney and certified probate real estate agent is always a good idea.